Injuries at work can lead to lost wages, medical expenses, and denied insurance coverage, all while trying to recover. The legal team at Mooney & Associates is ready for even the most complex workers' compensation cases. Mark Buterbaugh is an attorney there. So this is an interesting scenario. You get injured at work, your employer denies that the injury even happened. That seems remarkable. You know you were hurt. What can a viewer do if an employer does deny it ever even happened?
Well, and they do. They do for various reasons. They do for pre-existing conditions. Usually you see it in older workers. They do it if sometimes, people that I represent are tough. They're working in factories and they get hurt, and they may take a week or two to even tell their employer. That will draw a denial. And quite frankly, there's a lot of employers who are prone to just deny work injuries. Why? Because for every 10 employees that get injured, maybe 5 walk away and they save money on this. But if you are denied, you have to pursue your rights, or you're not going to have wage loss if you're out of work because of the injury, and you're not going to have medical care. And by calling us, we can file a claim petition against the workers' compensation insurance carrier and the employer, and protect your rights.
I want to backtrack. You mentioned pre-existing conditions. If you do have a pre-existing condition, is that something that can affect your workman's compensation if you are injured on the job?
It will affect it in terms of it'll probably draw a denial or skepticism, but it is not a bar to workers' compensation benefits. The court law has been very clear in that an aggravation of a pre-existing condition is a separate, distinct work injury.
Okay.
You see it typically with guys who maybe had a back surgery in 2007, 2008, 2009. They recovered from it, they go to work, maybe at even a new employer. They're doing fine, and all of a sudden they lift something and they injure that back again. It'll trigger a denial, but a pre-existing condition is not a bar to benefits, even though many employers will tell you it is.
And certainly if you're injured on the job, you should be able to get compensation for that lost time at work. What about pain and suffering? Is that something you can pursue?
Well, it is one of those things that I am asked frequently, and people think that they deserve it, and they do, but they're not going to get it.
Okay.
About 100 years ago, there was a great compromise, and it was called the Workers' Compensation Act. Employers gave up things, labor gave up things, and one of the things that labor gave up was pain and suffering. Workers' comp is an exclusive remedy. You're entitled to wage loss benefits, and you're entitled to medical benefits.
And now I think I know the answer to this question, because I've read this where I've worked at different places. But if you are hurt, can the employer require you to go to a specific medical provider or be seen by a specific doctor? Is that their call to make?
It can be. If they have a posted list of panel providers, and usually it's 6 providers on there, and they provided you a copy of that and you acknowledged it by signature, then yes, you have to treat with a panel provider for the first 90 days. But there's a lot of complexities in it, and the employer must follow every single step. So if you have any questions regarding, do I have to treat here, just call our office.
Very good. Really good information. It could help a lot of folks out there. You say, of every 10 workers who are hurt, maybe 5 walk away and just decide not to pursue it. So it's good to know that, no, they can pursue it, though.
Correct.
They should take action and give you a call. Thanks for being with us today
Oh,
on the
you're
program.
welcome.
Really
Thank you
good
for having me.
information.